and we are representing King County, New York, who is the respondent in this matter. I will be presenting the first issue, and my co-counsel will be presenting the second. Adult Fourth Amendment rights were not violated when Mr. Parker searched her iPhone, pockets, and bag. Because he had reasonable suspicion that Adele was violating the school rules that the officials also used, the least intrusive, most practical means of searching Adele in this matter. In Seattle, New Jersey, the Supreme Court held that the standards of probable cause required for searches outside school does not apply to school officials searching a student's purse or person. Instead, the standard reasonable suspicion is more than a hunch or a feel, and is based on specific details in this fact. CLO applies to our case here because the facts of this case are very similar to the facts in CLO. In CLO, the principal knew that the girls broke a school rule when the teacher found them smoking in the bathroom. In Adele's case, the principal knew that Adele was breaking a rule when she had a cell phone in school, where there was a no cell phone policy. When Mr. Park accidentally read "You smoking, Adele," this was definitely a fact that would give any school official reasonable suspicion that Adele smoking cigarettes or drugs. This reasonable suspicion gave Mr. Park the right to further searches Adele's belongings for evidence. When the mattress fell out of her pocket, again, this gave reason to a suspicion that Adele could be using the mattress for cigarettes or drugs. Therefore, the school had sufficient reason to search Adele's backpack for drugs and her cell phone for other incriminating text messages. The reasonable suspicion is much lower standard than probable cause, and the school definitely had enough facts and details to lead to a reasonable search of Adele's belongings. In Doe versus New York School District, the Supreme Court held that even though the school acts as a guardian for children responsible for student safety, for full-scale suspicionless searches violate the limited expectations of privacy without special circumstances. Doe applies to our case here because the search of Adele's home was a inadvertent file of her violating the no phone policy. The message "You smoking, Adele" gave reasonable suspicion to search Adele's pockets, which produced the matches claimed with the message provided reasonable suspicion to search Adele's bag. None of these searches were full-scale or suspicionless, therefore they do not violate law. In the search court held that non-policy school personnel are entitled to search a student if the search used is the least intrusive, most practical means of locating the offensive items in search, represent a proper balance between the student's right to privacy and the school's right. To make sure that rules are not broken, and we have to apply to our case here because of the most practical means of searching adult belongings also means that the Brooklyn Academy has seen that they were searching for eggs because for the past Halloween years there have been egg blowing But in this matter, when they were searching Hakeem, they found an illegal item, which is a .22 gun, inside of his pocket. But for searching Adele's phone, it was an accidentally, but he read Adele's text message with the box. Some other reasons why Adele rights were not violated include that even though there was a no phone policy, she had phones because her little sister was tutoring and she needed her little sister's car so she could go with the car. For these reasons, we strongly urge that the court allow the evidence found on the petition. Thank you.
Good afternoon. Harvey and James' Fourth Amendment rights were not violated. When Mr. Park and the officers searched the bag because they had reasonable suspicion to believe that Harvey and James had broken a school rule, and they used the least intrusive, most practical means of searching them. In CLO versus New Jersey, the Supreme Court held that a school does not need probable cause to search a student, person, or person inside a school. Instead, the standard is reasonable suspicion. Reasonable suspicion is more than a hunch or a feeling, and is based on specific details. In fact, in CLO, the court held that students could be searched in the school. Officers had reasonable grounds to believe a school or order of law had been violated. CLO applies to our case here because Mr. Park had a reasonable suspicion because the cell is a clear violation of the school. No cell phone policy. The youth smoking adult gave reasonable suspicion that a drug law was being violated. The message gave reasonable suspicion to search adult's pocket, which found matches. The matches provided reasonable suspicion that adult was smoking drugs or cigarettes. Both violation of school and local law